Take it infusion.
Item number 1.
Item number 1, my lord, IFA for the petitioner. Your lordship may recall that this matter, my lord, the learned tribunal passed an order directing them to grant me study leave. My lord, nothing happened, my lord. I'm compelled to file a contempt petition over there. But still nothing happened, then I have to approach your lordship, my lord. Your lordship can have it in the last order. There was a clear-cut direction by your lordship, my lord. Study leave.
But it's 50 years.
Yes, you are to give us a report today.
But I've got just result that he applied for the tiara, but he is not entered the tiara because he's crossed the age of 50 years.
No, is the tribunal's direction to grant him the leave?
No, but according to my lord directions, we have requested the department to consider it in terms of the my lord's order.
No, he is saying the tribunal directed to grant the leave.
Yes, my lord. Initially, my lord, I approached your lordship. Your lordship said you go before the learned tribunal. I went before the tribunal.
Where is the tribunal's order?
Yes, my lord. Tribunal's order is, my lord, at page. My lord, your lordship may find 128.
128.
And the state government also filed a requisition against the order passed by the learned tribunal.
27 তারিখ থেকে ডেট দিন।
So there was a positive direction to accept.
And against that we have challenge.
Which writ petition?
State of West Bengal versus Sopon Maji.
Obviously, we are asking you the number. Party will be the same.
The number.
It will have to be considered together.
Yes, my lord. If they are fine, my lord, both the
It
matters
will have to be considered together. Therefore, we are asking you, what is the number?
I'll supply the number.
We are informed by Mr. Mukherjee.
But 13 under the same heading, my lord, as a new motion. Both the
Right.
matters.
Yes.
ওটার নাম্বার দেবে, হ্যাঁ, আর একটা ফাইলের সঙ্গে ট্যাগ হবে। আমাদের নাম্বারটা দিয়ে দেবেন। 13 item number 2.
Well, item 2 also, my lord, my application, my lord, matter relates to, my lord, NOC of a doctor who wants to pursue, my lord, a recruitment drive conducted by the AIMS Kolani for the post of pediatrics, assistant professor pediatrics. Well, your lordship can have a look at a lordship's order dated 17th of December. জানি না দিয়ে দিয়েছেন স্যার?
Yes.
আমি তো জানি না। No, I've been told.
Huh?
Things have been sorted out. I've been told by my lord.
Then why to keep it pending?
the same heading बोलो ऐसा नहीं था
Then your issue is over. This is the original.
Yes, sir.
You give us a copy for the record.
Yes, sir. Or we kept with the records for us. But I do not need that.
But this is the original.
Original must be kept with the record. I will take copy, Xerox copy and hand over for supply to my land fund.
Okay. The original, no objection is to be kept.
No, no objection has to be given to him.
Therefore, we are saying this is original, no objection.
Yes.
And no objection certificate.
Disposed of as because of item 48.
item 48 দিয়ে দেবো item 48 বার করো ঠাকুর
The first one is the original, and second one is the photocopy.
adjourn motion का है वहाँ WP 247 of 25
247.
There are two issues of the person.
First one is the original copy,
এটা item 48 এর
and you can be sent by hard copy to my land fund.
কোথায় দিলেন?
Hey, what is the deal?
তোমাকে পাঠিয়ে দিন স্যার আমি দিয়ে দিচ্ছি well, I mean told my lord, I will be served a soft copy, my lord. Issue is the same. This matter will also be disposed of, my lord.
Just apart from the first paragraph.
Dispose na.
2 আর 48 দুটোই ডিসপোজ।
The requirement kept and no objection.
That is why I'm saying they are not.
Item number 3.
They are saying in compliance with the request also.
The respiration application, my lord.
Why on two days nobody is appearing?
My lord, this is a change brief, my lord. My lord,
That story will not cut any ice. This is not the way.
due to some.
There is no copy of the registration application. Details.
Yes, you have to show whether you are a full-time
I am a casual worker, my lord.
full-time casual worker or not.
Casual worker, my lord.
That is the only thing.
Only thing, my lord.
Yes. So from where can you show that you are a full-time casual worker?
And first of all, my lord, leave to file supplementary affidavit, my lord. My lord, the petition filed in State Administrative Tribunal and the review application were inadvertently not filed in the writ petition. So, my lord,
You will be helping the Legal Aid Society.
my lord.
Will you be helping the Legal Aid Society?
No, my lord.
You should. Why do you have to file a supplementary for these things? Your writ petition should be filed complete.
And,
Again, you will say change brief.
yes, ma'am.
That is a remedy for all things.
My lord, kindly come to the writ petition. my lord.
Can two.
Can 2 is, my lord, come to page 21, my lord, of the writ petition.
Writ petition.
Yes. This has been certified, my lord, that he is a casual worker of the office of the undersigned from June 1988.
See, you know what is the issue.
Yes, my lord.
Therefore, we asked you at the very outset,
My lord.
which document can show that you are a full-time casual worker?
My lord, page
We are not
21,
asking you for how long you have been working.
Page 21, casual worker, my lord.
So this is nothing. This is reliable and hardworking does not mean a full-time casual worker.
Dr. Chandra is a casual worker. It is
We
certified.
are asking you from which document you can say that he is a full-time casual worker. That is the only thing which is required as per the government decision to give you a particular remuneration.
Kindly come to page 32. Page 32, 3rd May 2016. Dr. Chandra, number 2.
No, first of all, where is the definition of full-time casual work?
There is no definition of full
Where is that? Where is that government decision?
casual worker, my
You
lord.
are claiming benefit under a government decision. Where is that decision?
My lord, kindly come to. My lord, 16th September 2011, page
Yes.
26.
Page?
Page 26. Earlier, my lord, this type of repetition has been, my lord, disposed of by your lordship, my lord, and my lord, that has been not interfered by the Honorable Supreme Court also. But I am handing over the orders also, my lord.
There is a judgment of this court.
Yes, my lord. Yes, my lord. Your lordship has passed the judgment, my lord.
Oh, by this bench.
My lord, by sitting with Justice
Acha, all right.
Bhattacharya, my lord. I am handing over this. And my lord, Supreme Court has not interfered also, my lord. State preferred SLP, my lord. Similar. Similar case, my lord.
Thank you. Welcome.
Hmm. Is there any order by the authority rejecting your claim?
No, my lord.
You have,
My lord, in this matter, my lord, in earlier matter, my lord, they have complied with your lordship's order.
no, we have not seen that yet. We are asking you in your case,
Yes, my
was
lord.
your claim considered by the authorities? No.
No.
Lord, give me 1 second. Please
Then what took you to the tribunal?
No, no.
My lord, to give the, my lord, benefit of 22nd, my lord, 23rd April 2010 earlier order, my lord. Because, my lord, at that time, my lord, he completed 10 years of service, my lord. On this ground, my lord, he preferred the application, my lord.
You are seeking review of the tribunal's order.
But that has also been rejected, my lord.
Where is the main order?
My lord, main order is, my lord, kindly come to page 68. My lord, page 63. Page 63. Page 63.
What is this decision of 23/4/2010?
My lord, kindly come to page 24. Initially, this order was passed, my lord. Thereafter, my lord, upon publication of 16 September 2011, my lord, these orders were superseded.
But on the date that you were claiming benefit of this 23/4/2010,
My lord,
the 11 memorandum had already come into effect.
afterward, my lord, 16 September 2011, my lord, thereafter, my lord. But that was my lord, in supersession of the earlier memorandums, my
The
lord.
memorandum of 16/9/2011 was very much in existence when your OA 8184 was being decided.
My lord.
You
my lord.
chose not to claim any benefit under that. You have
My lord, initially, my lord, 23rd April 2010, my lord. My lord, kindly let me read, my lord, memorandum of 23rd April.
no, we are not on that.
My lord.
We are on why you did not claim any benefit under 16/9.
And the subsequent memos, my lord. And the subsequent memos.
Where is your OA prayer in 184?
My lord, that has been in the
184.
supplementary affidavit, my lord. In-
Just
Yes, yes.
that
Just wait.
and one of these comments for deprecated. If he wants to amend the bidding, then you have to file an application for amendment of the original application.
No, this is not amendment. This is just supplementary.
In the supplementary affidavit, since these two petitions were not annexed with the
Some documents were missing, so she has filed. Yes, you are prayed for 16/9/11 also.
yes, ma'am. Subsequent memos also.
No, there is a specific 16/9/11 has been mentioned at
In
page
the yes,
19.
ma'am.
Did they file a reply before the tribunal?
No, madam.
The original order was passed on 2019. Application for review was filed, review was rejected, then they have charged. At page 63. Holding that is a part-time casual employee.
File a reply if you want. The learned age.
Item number 4.
I appear for the appellate petition.
For the
Appellate petition, manner. This is an application for review of the order passed by Honorable Justice Horace Tandon as his lordship then was sitting with your lordship. And I have moving upon notice, I have sub copy upon also upon the manner. When I filed this review application, my point was only Malat that we are not called on for arguing on merits of the case.
you were the
The defendant.
there are so many defendants.
There are so many defendants. I am the not contesting defendant. Your lordship will get it from the cause title. Defendant now 1 to 5. Page 2 of the review application, your lordship will find. The other, my lord, are not contesting, not contested even before the court below. Now the judgment is dated 5th April 2024. May I place it? is arising out of a suit for injunction, partition and injunction, and the suit filed, my lord, after 5 decades of the property settled by the parties by virtue
So
of.
therefore, what do you want? You want us to rehear the matter?
Yes, my lord, because my lord, my your lordship kindly peruse my grounds of appeal first.
What is it? Tell us.
Hmm.
Which
Madam-
ground? Which ground you are raising?
And I am taking the ground, your lordship kindly peruse page, my lord, page 18 of the judgment.
Yes. Yes.
Middle portion, your lordship will get it, the jurisdiction exercised. Has your lordship got it, my lord?
Yes, yes.
The jurisdiction exercised by the probate court as a court of conscience is limited to the extent giving sanctity to the genuinity and authenticity of the will and cannot travel beyond it. The probate court does not decide the title of the parties in the property, even if the same forms an integral part of the estate of the testator. And we do not find any embargo in approaching the civil court for declaration of title. We are therefore unable to accept the contention of the appellant that the defendant appellant has miserably failed to make out a prima facie case since the argument were not advanced on the merits of the impugned order. We need not have to delve into it, and points which have been asked is decided as aforesaid. And this is a point, the suit for partition, and they are an
Therefore, we are asking you, you want to re-argue the matter.
argue on the points of merits of the
You
case.
cannot, review cannot be utilized for re-arguing a matter.
I tell
The
you,
law is very clear.
my lord, under order 14 rule 2, your lordships, my lord, knows, my lord, court is under the obligation to file judgment on all points, on all issues. Well,
So if the judgment is wrong, we will rehear it as if an appellate court is hearing the matter.
my lord, this is a
We are not asking you that. We are asking you scope of review.
yes, my lord.
You are not satisfied with the findings. So there is a ground for review.
My lord, and top of it, my lord,
Yes.
pending hearing of this review application, my lord held that the suit is maintainable because your lordship.
So you are re-arguing the matter.
My
That is clearly beyond the scope of
your
review.
lordship kindly.
The way you are approaching the court gives an impression that it has been filed just like that.
I follow, my lord.
You have to fall within the grounds.
The review or
Exactly. Not to say that the judgment is wrong on this ground and that ground. That is not the scope of review.
that
You know very well.
that is your lordship.
Yes.
No, my lord, another finding I'm showing to your lordship.
There may be wrong findings.
Yeah.
There may be. We don't know. This is not the scope to look into these issues.
One other things I want to.
We will not look into the correctness of the findings. Please be sure that we will not look into the correctness of the findings. Please be sure.
My lord,
We are not going to exceed the
my lord,
jurisdiction
this is
of
my
a review.
duty, my lord, to place before your
No, it is your duty to first tell us which ground under the provisions is a review on which you are
my lord,
seeking.
your lordship
You are
kindly
saying this finding is wrong, this finding is wrong. That is not a ground for review.
my lord, your lordship kindly peruse, my lord, order 14, my lord. This is also apparent.
Maybe all the findings according to you are wrong. Maybe. We don't know. That's not the scope of a review.
My lord, I have CPC, your lordship kindly.
Yes, we have it.
And your lordship kindly peruse, my lord, order 14 rule 2.
Yes.
The court to pronounce judgment on all.
We are not on that, sir. We are saying we don't know whether the judgment is correct or not. We are not here to look into that. Come to the scope of review.
Well, that is
Come
my
to the provision of review.
Why, well, this is apparent according to my.
We will not enter that arena unless you satisfy us that there is a ground on which a review can be invoked.
This is my respect.
Sorry, will not look into those issues. We will not. You will have to come to the provision of review
Your lordship, my lord,
before coming to that.
now, my lord, there is a judgment of your, my lord, on the Supreme Court, what the scope of review has extended to a large.
So come with that. Before you enter into the merits like arguing a rehearing of the matter,
This
we
is,
will not permit.
this is not subject to correction.
Not at all, sir. You may try your level best,
Well,
but we will not permit.
Your lordship, and pending hearing of this review application.
Nothing.
Well,
It is a review confined to the grounds of review. We don't know whether the judgment is correct.
I shall have to
We
show-
cannot certify that the judgment is wrong. We cannot certify that our judgment is correct. That is not our scope.
Well, in that event, I shall have to produce before, submit before your lordship, my lord, the latest judgment of
You should have come with that. You know that is the first issue which will arise,
Well,
whether you are coming within the scope of review or not.
well, this is
It's
what-
not a rehearing forum, sir.
This is not.
You are proceeding as if it is a rehearing forum.
My lord has delivered judgment.
Please,
only on the
please,
point
please,
of mental
please,
ability.
please try to understand the court's query.
Well,
We will not exceed unless you satisfy that there is a ground of review. We are repeatedly telling you, you may try very hard, but it will not help you.
Madam, my
We are not going to enter into a rehearing and re-examine whether we have answered all the questions, whether the judgment is correct. We don't know. That's not the job of a review court. It's not the scope of a review.
I follow my lord, what is falling from.
So
the
therefore
lordship,
address us.
that we should go before the higher forum and.
We don't know. You may not go.
Well,
You may
this
decide not to go. We are not here to suggest.
This is the legal provision, my lord.
Sir, we are only saying satisfy us that you have a ground for review. We are not going to rehear the matter. Be very sure.
My first submission before your lordship, my lord,
First you decide on which ground you have filed the review. Where is the error of record?
my lord, under order 14, rule 2 of the code of civil
If you are arguing so much, that means there is no case for review.
my lord, and the second is, my lord, I'm trying to submit. before
See, you
lordship.
can't say everything. You can't say I
when-
will come with a judgment and you can't keep proceeding like this. You can't do both.
Well, then, my lord, I shall come before.
Come with that. If you are within a review, then only we will not hear you on merits at all. Be very sure.
For your lordship, my lord, I tell you another thing, my lord.
Learned
Pending hearing-
advocate, appeal. Next case.
And my lord, for your lordship, pending hearing of the review before your lordship, my lord, the Supreme Court has passed a judgment, my lord, holding that, my lord, the issue decided by your lordship, my lord, does not cover, my lord, the legal, my lord, the
Call the next.
judgment passed by.
Number 6.
Call the next.
Limited scope.
Matter, my lord, I am taking for 7 days time because I have not served the copy upon the, because the limitation, the copy should be served upon the
Which application?
review application and section 5 application.
Section 5, which application? CAN number?
And number 1.
The learned advocate for the
একুশ দিয়ে দে 21st Item number 7.
Mr. Primal Kumar Mishra is appearing in this matter as senior counsel. He is suffering from jaundice, my lord. I'm praying for 2 weeks accommodation.
Right.
What do you want?
Praying for 2 weeks accommodation, my lord. He's suffering from jaundice. He's bedridden, my lord.
Last time also you took an adjournment.
My lord, I was instructed so far, my lord. I have.
This is not the way. You don't want, if you're not interested, then leave it.
My lord, he is suffering, my lord. He's not well.
Who is not well?
My lord, the senior counsel who is appearing in this matter, Bimal Kumar Mishra, my lord. Vinay.
On a prayer made by MS so and so.
Item number 8.
In item number 8, Mr. Pankaj Banerjee is appearing for the senior counsel, but should I pay for only not today, please?
Why every matter has to be adjourned for a senior counsel? What is this? No, ask him to come. What is the big?
Kindly fix it on the next week.
Yes, this is arising out of?
Arising out of what happened, my lord? They were patta holders, my lord. I am for the ECL authorities, my lord.
For the
ECL authorities.
steel authority.
Yes, my lord. In that ECL authorities, my lord, there was a land which was supposed to be, but we were supposed to take land 2 acres and we were supposed to give employment. My lord. Now, my during scrutiny, we found, my lord, this person, my lord, the basis of their land, my lord, was a patta, my lord. It was issued to a minor, my lord. A minor of 2 years, my lord. A 2 years, my lord, cannot obtain patta, my lord. So, my lord, on that ground, my lord, we have stopped that, my lord. We have also asked the PLRO to clarify whether this patta is genuine or not. That is also there, my lord. Now, my lord, on that basis, my lord, the court has come to the finding that there is a disputed
What
question
was
of
the prayer in the writ petition?
it is to give employment.
To give employment.
To employment for the land user category. But if you lordships come to the writ petition or not, is 13, my lord. You also will find one.
And which is estate. Estate. Government allotted the said land till the persons who have no land. Tillers. Settlement. Settlement. One kind of settlement. No, not yet. This is from estate land. whether the age bar of giving patta, whether there is the age bar of giving patta.
Kind consider section 49(1) of West Bengal Land Reform Act, the definition of keeping of patta. But our cases is twofold. First, he was a minor, he was not able to grant patta. And second, my lord, this person, they used to live in Saitia. They're residents of Saitia, Birbu, and they had been issued patta of Andal in Bardhaman. My lord, if your lordship consider section 49(1), my lord, your lordship will find, my lord.
No, but in 2012, you have processed the claim with a view to giving the employment. You have done everything. You have got the medical also done, and then you have got some information from the BLL RO, and then he said that he was only 2 years at the time of issuance of patta.
Yes, but the basis of, my lord, giving the service, my lord, but mere processing of employment does not create an entitlement for employment, my lord. That's process, my lord, by this process which we have spent, that he is, whether he is fit for employment or not. But he is fit for employment. But my lord, mere processing, my lord, does not inculcate, my lord, employment.
No, but you have,
This, my lord, the land, my lord.
once you have initiated a process, it must be taken to its logical conclusion.
Logical conclusion,
It
my
need
lord.
not be in his favor.
Yes, my lord.
But you can't just keep it in the limbo like this. In 2012, you seek some information, then nothing.
But on that ground, my lord, so if your lordship wants, my lord, then we can, my lord, do one thing, my lord, we can consider his representation and disposal and give our reason, my lord, why we are rejecting it. That can be done, my lord. Our reason of
Unless there is such a reasoned order, he doesn't know where he stands, what he will challenge.
time for that order.
He cannot make out a case in a writ proceeding.
Well.
Because of these disputed facts, he cannot make out a case here. Whether the patta was rightly issued, wrongly issued, what was his age, whether he resides somewhere else and patta has been issued in a different district, these issues cannot be examined in a writ proceeding.
That's why the petition is not maintainable. That's the reason given by the leader.
No, but then he cannot be left remediless at the same time. You cannot just sit on the candidature, processing it 80% and then saying nothing.
No, my lord, the thing is that, my lord, when we acquire land, my lord, we keep the value also, my lord, and also employ. But
See, you are not doing them a favor. This is your scheme to give a job. Don't portray it as if you are doing a big favor. You are taking up the land, you are giving the job. You are giving compensation also. You are consciously doing this. It is not an act of extreme benevolence. It is a terms of acquisition. So the only thing is whether he is a beneficiary or legal beneficiary or not. You have processed the entire claim. You have looked into everything. In the last moment, issue has arisen that he is not. He was 2 years old at the time of issuance of the patta. That is something which has arisen at the last moment. So, why you have sat on it for such a long time?
But we were in a process of this information which we have asked from the dealer, it has not come to us, my lord.
Yes.
This has not come to us. That's why we were sitting in the there are, in the meantime, they have filed petition. In the writ petition, my lord, kindly see, my lord, last occasion, my lord, the dealer has also raised a doubt. The state has also raised a doubt. At the time of, my lord, passing the interim order, my lord, that time, my lord, I was not appealing, my lord, the state was appealing. The state had also raised the doubt, my lord.
State has?
Raised doubt on the patta issuance of patta. In the interim order, kindly see.
State was also a party there.
My lord, state was made a party by a direction of this honorable High Court. It has represented this.
Respond number?
But it will be respond number 5, my lord.
There are only four
There was a direction to add a state a party.
in
And
this
state-
proceeding.
In this proceeding, in the writ petition. If you not.
No, in the appeal or in the writ,
In this writ.
but the
My
impute.
lord, kindly see order dated, my lord, 1st of August 2023. Passed by Honorable Justice Lokita Banerjee.
But the order, impugned order shows only four respondents. Oh yes, BL and LRO
Red party.
on 1/8/23. He was implemented as a respondent.
Kindly see what the landed council appearing on behalf of the petitioner is directed to make BL and LRO, Pandaveswar area, Andal, a party respondent in the present proceeding. Kumar, there was a direction, my lord. And accordingly, my lord, if your lordship sees the impugn order, my lord, impugn order, my lord, kindly see Mr. Mr. Sengupta and Mr. Pal, my lord, appear for the state. And my lord, they state, my lord, on behalf of the state respondent, it is submitted that the entire claim of the petition is suspicious and materialless. It is further submitted on behalf of the state respondent that on the basis of the query raised by the respondent number 1, all the factual details of the alleged by the petitioner are highly debatable and require an elaborate investigation. For example, at the time of issuance of patta, the petitioner was 2 years old. Well, that is the stand of the state also. Not only our stand. Although, my lord, we have not received a reply from the state, my lord, of the letter, my lord, which is a letter in which we have raised a doubt, my lord. That's why, my lord, we put a process. Is the repetition?
Why I am saying this? To 64. His name is here. And someone else 7. In next page. Meeting with PLN. Next page. Page 16 is important. In this connection, I am directed by the general manager. We can process the claim. We have gone to this stage. And then here also, the name of the candidate are important. You mentioned everywhere. And then suddenly this letter comes.
They processed everything.
Then on this order also it is not clear that he was.
Reply has been given, inquiry has been made to be heard.
So there is no response to this query of 10/7/13.
Till date. That's why that is the reason why we should not process. Kindly consider the letter that is at
No, because they were made parties to the writ petition. What did they say? Did they file any opposition?
No, they have not filed. The opposition was not asked for also. It was rejected.
Then why they were made parties? Why they were made parties?
In order to clarify this doubt, but Justice Banerjee, Lokita Banerjee at that point of time had hired him at PLR just to clarify this position of our stand. That's why he was made the party.
So where is the clarification? That is what we are asking you.
kindly see, on that day also, they said that investigation is required to be made. But kindly see in their submission, investigation has to be made. Wait a minute, you'll yes, my lord, the state also in this point, my lord, and thereafter decide, my lord.
No, we are not going to decide. It cannot be decided in a writ proceeding. What you are saying, they said suspicious and meritless. Only on the basis of a suspicion they have held it meritless.
But even, my lord, if you consider the act, my lord, land reform act, my lord, can you see the definition? My lord, top of, my lord.
No, we are not going to look into
My
that.
lord is 2(8), my lord, and also, my lord, 49(1), my lord. But your lordship will find, my lord, the land or patta land is given to a person in order to hold that land and to cultivate it. Now, my lord, a minor cannot, my lord, hold the land and cultivate the land, my lord. A person who is 2 years of age, my lord, patta cannot be given to that person, my lord, to cultivate the land. Here, my lord, the land was given to 3 persons, my lord. Kamla Rai, but the grandmother, mother, Mita Roy, and Samrat Roy. 50 decimal, 50.50, 0.75, and 0.75. Total, my lord, we will require 2 acres of land. But if 2 acres of land is there, my lord, then, my lord, we will proceed with the employment. That is our scheme, my lord. So now, just because this 0.75 is become doubtful, my lord, that Samrat Roy is giving a patta, my lord, and showing that he was 2 years of age. So, my lord, it's not coming to fitting our scheme, my lord. That is the difficulty. Otherwise, we have no problem in giving employment.
No, so you must take a final decision. That is all we are saying. Whatever.
Direct as well, we'll take a final decision.
Yes, what do you want?
Kindly adjourn for the lordship.
We will direct them to pass a final order on your claim. Right now, your door has been shut.
For once, lordship.
Huh?
Kindly hear my senior for once after that.
Adjourn, my lord, let them see what they refer past. I also so much.
On prayer made by the learned
Item number 9.
Time for that. Yeah, my lord, what happened, my lord? In this matter, my lord, in fact, I am, my lord, claiming, my lord, here, my lord, the MMCC was granted, my lord. Our steep. This is section 5 application, my kindly take up first, my lord.
This arises out of a review.
Yes, my lord. In review, my lord, the order was modified. So, my lord, the doctrine of margin is applicable, my lord. At first, my lord, it was directed, my lord, that we have to pay MMCC from 15 May till 22nd January 2025. But it was that 6% interest was given till 28 February 2025, and thereafter 8%. Now, in review, my lord, it was increased, my lord, from 16 April 2011 till 26 January 2025, and the interest was reduced to 6%, my lord. So, my lord, this become now final, my lord, upon us, my lord. So, my lord, I have to challenge this order, my lord, under doctrine of merger, my lord. But in effect, my lord, I am challenging both the orders, my lord. It's only, my lord, relating to the period where which people pay, my lord, and interest part, my lord, you also will consider.
Earlier, there was in the base order, there is no interest.
My lord, there was interest, my lord. It was 6%, my lord, till my lord, 26 January 2025. Thereafter, my lord, if we don't pay within that, my lord, it will be increased to 8%. That was initial period, my lord. Thereafter, my lord, it was turned down to 6%, my lord. Now,
So what convert? It was 6% anyway.
6% anyway, my lord, it was reduced to 6%. If suppose we are not paying, my lord, after January to the
In the
Up-
base order, also 6% has been granted. In the review, also 6%. So what is the change?
Well, the period is also the 6% must first till kindly see the impin order, my lord. I'm just placing the impin order first for you, lord. Penalty
The
position.
review has only changed the date of demise because it was wrongly recorded. There is no substantial review.
But date of demise, my lord. So, my lord, the period time.
2 days.
My lord, one month.
Huh?
1 month. My lord, previously, my lord, it was my lord from 16.
Oh, from 14th to 16th. Yes, 1 month. So what is the big deal?
So, my lord, why?
That is a correction of a typographical error.
My lord,
That is not a review.
but I am challenging this, my lord, because I say, my lord, the MMCC, he is supposed to get, my lord, till the sun is kept on live roster, my lord. That is till 2017. And 2017, my lord, we are also ready to pay, my lord. We have made calculation also regarding that, my lord. But after that, my lord,
But that is not something which arises in the review order.
but it was also a point, my lord, taken in the review application. It was not considered by the court.
How can you
But from the
rehearing
memo
on
I
the
can
same
show,
point before the review court?
and memo I can show, my lord.
You can, but that is not the subject of review. That cannot be a subject of review. How you can re-argue a matter in a review application?
But, in that review application, we have said that.
You may say anything. Rightly, the court has not considered. It is the review. It has to the extent of the scope of review order has been passed. Other things cannot be looked into in review. Come to the base order. Where is the base order?
Yes, my lord. Kindly come to my lord. Page, my lord. Page 52, my lord.
Page
52 of my stay application.
Where is your opposition filed in the writ court?
No opportunity given.
Huh?
No opportunity given.
Where you have said that no opportunity was given. Show from your memo. You appeared in the writ court.
No, my lord.
Then how you know no opportunity was given?
From the order, my lord, it's not reflected, my lord, that
Where is that ground? Where is that averment made in the appeal?
at that point of time I am right, but it was represented by other.
So therefore, before
But
you
I-
make a
you
submission, please go through the averments, whether it is your client's case or it is not your client's case.
But that point has not been.
That is not your case. We know, therefore we asked you. How can you make such a submission?
But from the orders, my lord, if you lordship.
So you will say anything, whether it is client's case or it is not your client's case. Maybe they didn't want to file.
My lord, that, my lord, really I am not.
If you don't have instruction, how you can say that?
I stand corrected. But if your lordship see the scheme, my lord, schemes, my lord, I can show to your lordship, my lord, from the scheme, my lord, if your lordship will find that we have to pay MMCC till, my lord, he is in life roster, my lord.
আচ্ছা কোথায় একটু দেবে না? আমাদের কাছে আসেনি কোনো। না
Where is the coal wage agreement?
my lord, 9.5.0.
It's not in the record.
My lord, it's
It is not part of the record.
Kindly consider 9.5.01.
Huh?
9.5.03, my lord.
9 point?
5.0, my lord. Nine point 5.0, particularly 3, my lord. In case of death, either in mine accident or for any other reason or medical unfitness, under clause 9.4.0, if no employment has been offered to the male dependent of the concerned worker, and the concerned worker is 12 years or above in age, he will be kept on a live roster and would be provided with employment commensurate with the skill and qualification when he attain at the age of 18. So, my lord, when he is attaining the age of 18, my lord, from that time, my lord, will process the employment, my lord. During this period, the male dependent is on live roster. The female dependent will be provided with monetary compensation cash as per rate, as per para 1 and 2 above. So, my lord, till the person, my lord, is in live roster, will provide for MMCC, my lord.
So you have given him employment in 25
My lord,
when he became 18 years.
in 2017, January 2017. From that point of time, my lord, we start, my lord, our employment process, my lord. Because, my lord, if a person is not 18 years age yet, my lord, we cannot process the employment, my lord.
He became 18 in 2018.
18, sometime in 2018.
No, you said 17. From where you have said 17?
Let me say, এটা দেখো age still would say 17. I got a calculation in that it was mentioned January 2017. That's why I was saying.
No, the order records he became a major in 2018.
Let me see the date of birth minute first.
So after 2018 to 2025, what they will do?
But that period, my lord, that is a separate cause of action. But if
Separate cause of action.
according to me, my lord, your lordship will
What do you mean separate cause of action? What does your scheme contemplate? After 18 years, what is to be done? They are to be left just like that.
Scheme does not say so, my lord. That
What does your scheme say after 18? They are to be left just like that. Huh?
To provide employment.
How, if it takes 20 years to provide employment, then they will stay just like that.
But if suppose, my lord,
Don't suppose, in this case, you have taken 8 years. What they will do for 8 years?
My lord, that period of time, my lord, then my lord, he will be entitled to my lord, back wages or something like this, my lord. If there is a
What? Something, whatever comes in your mind. Will you decide on a case-to-case basis? That in this case we'll give back wages, in that case we'll give 50%, in this case we'll give 20%. Where is that discretion, we are asking you?
that is not there.
It's not there. It clearly says till employment you have to give MMCC. So what is wrong with the order? That is why we are asking you.
But in this
On attaining 18, you have to process. You take 7 years and then you challenge the order. What is he supposed to do?
But giving employment, there's a procedures, my lord. Your lordship will see the.
Very good. So therefore, what we are not, you have done nothing till he filed the writ petition.
No, my lord.
In 24, he has filed the writ petition. In 25, you have given the appointment. For 6 years, you were sitting with hands folded. Or you may be doing a lot of work, but it was not manifesting in any relief to him. So what he will do for 7 years?
If your lordship sees, my lord, not our representation, we were asking them, my lord.
We don't know. Your intention is apparent from your action.
But first of all, my lord, we were also asking for the bank account to be provided to us.
That is over, sir. Don't rake up that issue. That is over.
that,
He was a minor. What do you expect him to do?
but in reality, my lord, the bank account was given just in contempt proceeding, my lord, to us, my lord. Bank account was given to us.
What do you expect him to do? That we are asking you.
But I am asking, my lord, but I am praying before your lordship, my lord, that but kindly admit this appeal, my lord, I will pay, my lord,
What admit? We are going to dispose it off. Come to 9.5.03. There is nothing. It is very clear what it says. You read it.
kindly see, my lord, 9.03.
In case of death, either in mine accident or for other reasons or medical, if no employment has been offered, this is the what it says.
And the male dependent of the concerned workers is 12 years and above in age.
He will get MMCC. So if no employment is offered, he will get MMCC. That is the agreement.
But MMCC we give to the mother, my lord, not to the person.
To the female applicant, the male applicant will get the compassionate appointment. If no employment is granted, you will give it to the female applicant till such time the employment is granted.
Also kindly, my lord,
It's very
kindly
clear.
see, my lord, 12 years of age, he will be kept on a live roster and would be provided with employment commensurate with his skill and qualification.
What is the meaning of live roster? That we are
Live
not.
roster means, my lord, till he attend 18 years, my lord, we are keeping him in a live roster means, but we will consider him when once he attend 18 years. That is the live roster. The period, my lord, which we keep from 12 to 18, my lord, is the live roster. From 12 to 18.
So actually it is a way of saying that it will not come barred by any delay. His claim will survive till he attains the age of 18. But in the meantime, MMCC has to be paid, whether below 18 or above 18. The rule does not say, the wages agreement does not say.
It states that during the period the male dependent is on live roster, the female dependent will be paid by monetary compensation.
Correct, correct.
That's why, my lord. But if a literal rule of interpretation is applied, my lord, it's clear, my lord, it says that till he is in live roster, MMCC will be given, my lord. And my lord, I can show judgment, my lord, it said, my lord, a larger bench, it is a 3-bench judgment which says, my lord, this NCWA, my lord, you cannot neither add a word or not subtract a word.
Correct. Neither we will do it nor you can do it.
Nobody can do.
Nobody
Because,
can
my
do
lord,
it.
it's a
That law is
settlement.
very clear.
It's a settlement between.
Yes.
That's why, my lord.
And it is also a law that such a document which is aimed at a social benefit, it has to be interpreted in furtherance of the objective, not to defeat the objective. That is also a very settled law by the apex court.
But I was saying, my lord,
So what is there in 99.5.03 which comes to your rescue? That we are trying to see.
9.5 but this during that period the male dependent was on live roster, the female dependent would pay monetary compensation as per the rate as per para 8. During the period of live roster, but if you also define live roster, my lord, that is, my lord, from 12 to 18. My lord.
Therefore, we asked you at the very outset what they are to do from 18 to 7 years. What does the agreement contemplate that such a person, how they will survive for the 10 years you take in given the employment? That is what we are asking.
Survival, my lord, if your lordship says, my lord, the wife, my lord, gets, my lord, other benefit also, my lord, pension, gratuity, leave encashment, everything they get, my lord.
So in addition to that, they
in
get
addition to that, this is MMCC.
the MMCC is given.
In addition
Correct.
to that, MMCC, my lord.
So you know that this they are required to be given. You very well know that this is required to be given.
But my lord, we cannot run up from that. That is an agreement, my lord.
But then that what changes after 18 years? Where is that provision that after 18 years it will not be granted? That we are trying to see. Your whole case is, if we have understood, that we'll give it till he is 18 years, after that we'll not give. Because after that he becomes eligible for compassionate appointment. If we take 20 years in giving the compassionate appointment, we will not give MMCC.
My lord, kindly
That appears to be the substance of your submission.
So, my lord, then I'm molding my submission, my lord, to the extent, my lord, which I can get, my lord. So, then, my lord, kindly consider this, my lord. So, my lord, our inaction start, my lord, from, my lord, the age he attained 18.
Correct.
From that period of time, we have
7 years in action on your part.
But here, my lord, the trial court has given interest, my lord, from the date of death. Interest on MMCC from the date of death. And MMCC also from the date of death till he attained the majority.
Have you paid the dues without interest?
But if you lordship kindly, my lord,
You pay that, we'll consider everything.
But calculation is ready, my lord. We can pay within 2 weeks, my lord.
Within,
The calculation is ready, my lord. Your lordship, once, my lord.
pay whatever is admissible as per your calculation.
My lord.
Then we will hear the matter.
Yes,
Your lordship, kindly permit
But
me, my lord, to
30,
say
12 to 13 lakhs, my lord, he will be getting, my lord. My lord, we will pay, my lord. And we'll bring the calculation sheet also.
Yes.
Lord, kindly see the Lord paragraph.
Let him come with the calculation. Then
Your lordship, kindly bear with me for 2 minutes only. Lord. Lord, the review application, the appeal, present appeal arising out of order passed in review application.
only.
Yes, my lord. Kindly see, Lord. There is nothing changed in the order of the review. Your lordship, kindly I want to turn up. Lord.
The appeal is only against the review order.
Yes, my lord. Kindly see, Lord.
Because, my lord, the
Lord,
improvement of,
yeah,
that was
we
my,
have in review.
that's why I
Lord, the findings that given by landed judge, my lord, kindly, I want to turn up. Lord, kindly attend again on page 64, my lord, nothing changed. Only typographical error. So far as the rejecting of review application, lordship, no, my lord. Order 47, rule 7 is not permissible, my lord. Kindly see, my lord, nothing changed in the review law party that point taken by my landed friend, my lord. Nothing changed. This only changes of dates that's given in the review application. Nothing article that point before the landed single judge, my lord. Your lordship, kindly see. So that order has not been the mother order that has not been challenged. As I have understood, so far as CTC is concerned, I am not saying that this court is bound to strictly follow the CTC and discretion of this honorable court, my lord. But so far as rule order 47 and rule 7 is
Let him come with the calculation. Let him come with the calculation.
as your lordship,
Yes.
as your lordship.
The learned advocate for
Item number 10. 10 to 13, my lord.
10 to
12.
Oh, it is part of that
Yes.
big batch of cases.
My lord, 18th of November, my lords were pleased to direct the alleged contemner, the chairperson of the council, to file affidavit as regards compliance of the court's order.
I have filed, my lord.
My lord, we have not been served with copies.
That's what
Get it to
his lordship.
My lord,
Without-
4 matters, 4 separate affidavits are required.
But in the affidavit, lordship will find, my lord, starts with paragraph 4, lordship. The prisoner submits that the court internally directed the authorities to prepare a panel on merit wise, which would include all candidates of the unreserved and reserved category, and in the event any of the applicants are found having obtained more marks than the last cut-off marks as disclosed in the writ petitions, they shall be given an appointment in the existing vacancy or anticipated vacancy for this year or future year thereafter. In terms of that order, the authority prepared a panel and appointment was given to the eligible candidates. These petitioner obtained 35.056 marks, wherein the last cut-off marks as disclosed by the petitioners is 38.0772. So petitioner does not come within the zone of consideration.
What is the name of this Swapon?
Swapon Orav. And I have also annexed, my lord, a chart, my lord.
Yes, we are looking at that. 35.05.
Yes, my lord. Lordship will find, my lord, the last name. Swapon Orav, number 16.
Yes,
These
35.
16 candidates, my lord, are not come within the zone of consideration.
Only
So
these
for
16.
These 16. So for the rest 59 or total 70, my lord. Rest of them, everyone will
verify.
give their
I want to file an
You
exception.
verify. You verify. Give him a copy of all the.
My lord, in all 4 matters, my lord, I've been handed over
Now, my
one.
lord, I will come back. Lordship, this called on one by one thereafter because all these are separate applications I have to file.
So different order has to be passed, or it is the same.
Because
My lord, one order will suffice.
So, my lord, I think, my lord, these the submission
Just-
is same, my lord, but
Just please come to this panel.
yes, my lord.
The remaining 3 are in at which serial?
Now, my lord, out of remaining 3, my lord, I say, my lord, 2% name lordship will find in this.
Hmm.
That is Taposh Malik and, my lord, Mohadev Pandit. Taposh Malik, lordship
Yes,
will
we
find
have got
Mohadev
it.
Pandit is 9.
4, 9 and 16.
4, 9 and 16. Now, my lord, the another matter, that is item 11, my lord, there is a typographical error on the part of the office of the commissioner. His name is Nojrul Islam. But lordship will not find his name because that gentleman has come within the zone of consideration.
Oh,
The only things is what happened is, my lord, in that case, my lord, that his name has been wrongly recorded as Nurul Islam in the serial number 12 of the chart prepared by the Commissioner of School Education.
Nurul instead of Nazrul.
Nazrul. Now, my lord, on DPSC on 19th of August wrote a letter to the Commissioner's office, my lord, indicating due to mismatch of the name of the candidate appeared serial number 12, appointment letter has not been issued. So unless and until this has been clarified, my lord, we will not issue any appointment letter. So for that gentleman is
So what
concerned,
is, how do you propose to resolve the issue?
let this gentleman go with the office of the Commissioner of School Education along with his documents that Nojrul Islam is not, his name is Nojrul Islam, not the Nurul Islam. Because
No,
he
but
has,
he will go only if he has committed a mistake. If the office has committed a mistake, then what he will do?
now the fact is, my lord, he has obtained 46.3.
So he is way above.
Whoever,
Yes.
whoever. So he is definitely within zone of consideration. But my lord, unless and until this,
No, but is the name appearing with the father's name?
yes, my lord, father's name is Sheikh Sirajul Islam, Sirajul Haq. And my lord, in the affidavit, my
Because
lord,
name and address both is there. Roll number is also there.
yes,
Even the photograph tallies.
So if there is a typographical error in the name, that hardly matters. It is
that's what,
inconsequential.
that's what.
So it is for the officer to rectify what they have to do.
If the Commissioner of School Education office sent me their details, my lord, we will give the appointment.
They are
to them.
parties.
Yes.
Yes, everyone is party.
So they are represented by?
Right now, আরে কত নম্বর আইটেম 11 এ তুই আছিস তাহলে কে আছে খবর নেই
Who appears?
I don't know, my lord.
Who appears for the state in 11?
Lord, I can indicate one thing.
Yes.
The mistake was not committed by the commissioner. The mistake was committed by Mr. Boshumollik's client. I have the document.
What is it?
It is the admit card which was issued to me on the 1st of December 2009, and after this was detected, my lord, I submitted an affidavit indicating that I am the same person. I can disclose it in my exception, my lord.
On 19th,
So
Milord, I
just one by one. This is item 10.
item 10, Lordship has.
We have taken up.
Yes,
So
From
10,
4 hours.
12 and 13.
13,
10, 12 and 13 same order.
same order.
So 10, 12 and 13. All right. 10, 12 and
To you
13.
is concerned, Milord. Taposh Malik, may I file my
Yes.
affidavit? And Milord, these are the, I have served the copies.
A report in the form of affidavit is being filed. Full stop.
Third February. But to go 784. Get the order holo. So 10, 12 and 13. Item 10, 12 and 13 এর ফাইলটা ওইটা
এটাতে আমি আছি।
10 হচ্ছে 783 185 8828.
This is 789.
787 probably.
That's it.
784.
Take note.
784. 784. No, where is the affidavit in this?
No, I have not filed it because he is a successful person, Milord. Only there is a mismatch in the name. That's what, Milord. Otherwise, he is eligible for the get the appointment because his marks is much more than the cutoff marks, Milord. But this is the document which has been on the basis of which, Milord, we have wrote a letter, Milord. I have only one copy, Milord. Kindly see the serial number 12. His name is appearing as Milord Nurul Islam. 12, Lordship.
Candidate's name mismatch.
Lordship.
Lord, all along in my educational testimonials, it is Nozrul Islam.
Nazrul.
Yes.
10, 12, 13. Single order.
So the name, father's name and village address, all is there.
Yes.
So there are 1, 2, 3, 4 fixed parameters and one parameter which you say is variable.
That is not.
So what is there?
We have nothing to do, Milord, because of that document which I have handed up to his Lordship, on the basis of which, Milord, we have wrote a letter on this document is of 8/7. Now, Milord, On 19th of August, my lord, we wrote a letter to the office of the commissioner indicating that serial number 12's name is mismatch.
So what do you want him to do? What the commissioner is to do in this regard?
His name, my lord,
You are the agency who has conducted the exam.
no, my lord, we will only give the appointments, but other part is concerned, that has been done by the office of the commissioner, from where, my lord, the list was come to us, and accordingly we have given the appointment on the basis of the list submitted to us.
No, what was the process? I have not gone through the order.
Process is, my lord, the in terms of the order of this court, matter has been traveled to Supreme Court. Thereafter, Supreme Court, as per direction, entire list has been prepared of the 79 persons. In terms of that, my lord, all these 79 names has been sent to the office of the Commissioner of School Education. Now, from there, my lord, they have verified everything, the testimonials and all. Thereafter, they send this list to us, my lord, who is eligible and who has not come within the zone of consideration.
This annexure A has come from them.
From them, my lord. Everything is come
So
from
they
them.
are finding a mismatch because you have sent the mismatch name.
That is, my lord, so far my submission is concerned, my lord, in this regard, my lord, my council has sent a letter to them on 19th of August, indicating that serial number 12 appointment was not given because due to mismatch. We have indicating that, my lord, in our letter.
Hindu. EPSC হুগলি আরো পরীক্ষায় আমি জমা দিয়েছি, এফিডেভিট জমা দিলাম, এফিডেভিট জমা দিয়েছি 18ই মার্চ, ছবি ট্যালি করছে।
আচ্ছা, এটা 18ই মার্চ তো 19/8 চিঠি দিয়েছে, আর ওইটা খরচ দিয়েছে একটা 8 সালে।
কাউন্সিল বোর্ডের এখানে কোনো রোলই নেই।
There is no letter of August, there is a letter of July. So he is to be issued appointment letter by you.
Yes.
Unless and until they send me the correct name. That's what I'm saying, my lord.
Lord, may I just indicate? 2009, the test happened. 2009, I applied. The test was conducted by the DPSC, District Primary School Council. I was issued an admit card by DPSC.
Having the correct name.
No, incorrect name. I assailed the selection process in a writ petition where my name features as Nazrul. Went up in appeal, my name features as Nazrul in the base order. At the time of verification, after the SLP was dismissed, I was told there is a mismatch. I submitted an affidavit with my photograph, my lord, which was affirmed before the first-class judicial magistrate at Hooghly. The photograph tallies, correct name given. The mistake was committed by the agency who conducted the examination. They sent the inputs for approval to the Commissioner of School Education, and the Commissioner of School Education has reacted. Now it is for them to rectify it. Lord, I can show the admit card and the affidavit, my lord. I have a copy where the photograph even tallies.
This was submitted at the time of examination.
No, at the time when verification happened.
So if you know there is a mistake, what is the problem?
This particular, that's what I do not understand. Then if that be the so, Millard, then why such letter of 19th of August, Millard, occurred? 19th of August, Millard, the District Primary School Council sent a letter to the office of the commissioner.
You are representing the council.
Yes, sir.
So why you have written such a letter when it is already
That's
clear?
what that's what I have also surprised, Millard. That even how this has been done, Millard, when they are fully aware, if they have at all these documents, Millard.
Yes,
then
you have submitted to the council.
why,
Yes.
why such letter has been issued?
You share a copy with him. He will take instructions. Very well. He will resolve it.
Yes.
No order is required to be passed.
Because that's what
Because there are at least 4 parameters which match.
Lordship.
Father's name, address, his roll number, photograph, everything is there.
I am not disputing anything with regard to that, because this person is otherwise eligible.
Yes, take down. Insofar as the present
এই কাগজগুলো দিয়ে দাও জোসেফের ফাইলে যেগুলো
give the paper. You please share with him whatever you have given so
Yes,
that he
yes.
can take appropriate instructions.
Aisha. Grateful.
Item number 14.
Mapping for the alleged contemner
That I have come after watching the list. That he works in police department, probably that he is not there in initially posted in Asansol, but for his job. But probably it has come back unclaimed for that reason. But a copy may be handed over. And one more thing, because there is a review, filed by us. That is also pending. No, that needs to be admitted first. Review.
What is the order?
Order.
But initially, after this content application was filed, now they are paying only 21,000.
So before the review is taken up, you have reviewed the order.
Well, what happened, I tell you, Lord, as per instruction, which came, Lord, my commissioner, my appointing authority, alleging, her infirmity in, maintaining herself. And, he informed me, I used my good office, say that whatever has happened, even divorce is there. Because there is a child, you keep on paying 21,000 as interim alimony, granted during pendency of the appeal. That was the figure, granted during the appeal, which was running. Now, that amount is being paid on my instruction that for your child's sake of child, you keep on paying. Don't stop it, that amount. But with regard to the amount which my lord granted that subject to payment of 50,000, that portion is under review. Because his salary is 70,000.
So therefore, we asked you before review, you have reviewed the order.
No, it's.
Why you are not complying till such time it is taken up?
No, I tell your lordship,
Is it open to you to modify the judgment like this? Then
it's not that.
how you are giving such an instruction to your client?
No, it's not that, I am reviewing the entire portion.
So whatever you want, you can review, subject to
It's not like that,
what kind of submission you are making.
This
That I have instructed him not to do this. Very good instruction.
I have instructed him to pay the amount, which was
He has to comply with the court's order.
I know,
Where's the question of any lawyer saying that you do this and you do that?
no, his salary is 70,000.
We don't know.
That
is something to be considered in the review.
That's exactly.
You have to come bona fide.
I, say, to show my bona fide, I have paid 21,000, this, which was there, after considering my salary, which was granted. Now, the portion of 50,000 is under review. I say, if that review is taken up, this content goes.
No, we are trying to examine your bona fides.
If I pay 50,000, then I die, without food. That's the problem.
So two people can survive in 21,000, but one person cannot survive in 21,000.
Rest, I have to.
Please tell us that two persons can survive in 21,000, but one person cannot survive in 21,000.
I'm just putting this question to myself.
What kind of submission you are making?
After divorce, there are.
We are not on that. There is an order, right, wrong. It may be whatever it is. You are obliged to comply with that order. There is no scope for any lawyer to give an instruction that you comply 50% and you comply 25%.
I can show, today, my respectful humble submission.
We don't know. Maybe in the review you will succeed. We are examining your bona fides.
Exactly.
Is this the way?
Today, if my review succeeds, then this contempt goes. There is no contempt.
Wonderful submissions you are making.
This goes. Now, second is,
he is a government employee.
He is a police officer. The police officer. Now, two things could have happened.
He may have to face the music for such instructions.
I reply to this contempt application. A copy myself, I will use an opposition to this. Because otherwise, what happens, today, if my lord sees the order, my lord's order, this is somewhat conditional order. If my lord sees the judgment, which is being passed, there is a condition imposed. The condition is, if you do not pay, as if, the divorce goes. If this is a condition, then in my respectful humble submission, can there be a contempt?
We don't know. We are not there. As of today, we are at this point that there is an order which has a specific direction. Whether that direction is to be complied or not, or any lawyer can give an instruction that you comply 20% or 50% or 75%. Is it open to you to give such an instruction?
My instruction comes because on the sake of child. I use my good office for the minor. It's not at all.
Very good.
For even
so it is your benevolence.
The child is always his. There is a divorce or no divorce. So, my lord, if for the sake of child, if I use my good office, my lord, to say that you pay for the sake of the child.
Otherwise, you would not have paid anything.
My lord, if my review is allowed, my lord, today.
We are not there yet. Again and again, you are saying the same
That's why I
thing.
said, my lord, kindly takes up the review along with this content. My lord, don't take this content, my lord, in isolation.
He did not take any steps to get the review application listed. And now today they.
When you have filed the review?
On the, my lord, within 30 days, my lord, April for the
April lordship, they were sitting tight.
within 30 days. We have
And they
filed.
have not paid anything. They have not complied with your lordship's solemn order.
No, my lord, because my lord, after that, my lord, this bench, my lord, which was partly ordered, his lordship retired.
That was in November. And they have
I could
filed
not
in
get it
April.
listed. Justice Des bench.
Yes.
My lord, kindly takes this review, my lord, before this bench. Now this bench can take up the review. Since my lord is the presiding judge, my lord, available.
বিরাজের ফাইল চলে গেছে উপরে
Judgment to Calcutta. Dicky.
Where is the review? Give us the review number.
Number 95 of 2025. 95 of 2025. I mean, I write on a slip of paper.
Give her a copy.
Lordship, we have no objection if the review is heard out. But before moving that review, Lordship, he has to clear all the dues. Because a person has to come with clean hands. He has to comply with it, then he has to move it. Because he has filed it on April. Until Lordship January, he was sitting tight. Because the regular bench was not there, but we mentioned it, we got it admitted, this contempt application. Yes.
I mentioned it when Justice Day was there.
Yes, we also moved it.
Constituted, but
Yes.
after that I did not.
No, but at our prayer, the bench was reconstituted.
We'll see. We'll see. Give the review number. And you are appearing on behalf of the contemner. What is that? You are giving an affidavit of service.
That is the affidavit of service, Lordship.
Review number.
It came back with endorsement unclaimed. ওটা কোথায়? এটা?
Affidavit of service. Take down affidavit of service. And give that copy to him.
Yes. Postal article.
You also give a copy of the review.
And in the meantime, let Lordship comply with the order. Let Lordship at least kindly record my submission that unless he complies with the order, he will not be allowed to move the.
We'll see when it is taken up. Don't worry. We'll see. It is just now being listed. We are not passed any order.
খামটা রেখে দিন।
Hmm.
খুলেও দেখো, তুলে দেখে নাই।
3 তারিখ দিলাম ডেট 3 তারিখ
And Lordship, on the next day, let the alleged container be present, Lordship.
You also give a copy of the.
On the next day, Lordship, let him be present.
Let us see first.
item number 15
Your Lordship, the respondent 2 and 3.
এটাও রেখে দাও না ফাইলের সঙ্গে ট্যাগ করে 7
It has to be sent to the department, then make it returnable after 2 weeks.
না না বোকা বোকা ফাইলটাই নামিয়ে দেবো হুম হুম হুম
Time for the appellant back.
Your Lordship, I am for the respondent number 2 and 3, Your Lordship. Due to some personal difficulty, I am being led by Senior Advocate Indranil Roy. He is not being present at the court today. So, Your Lordship, any day in the next week will be okay.
This arises out of writ court's order. Appeal is by the writ petitioner. As paid by the learned counsel for the respondent.
The paper book has already been filed.
Hmm?
But this matter has been heard by the other bench several days. My lord. Paper books are filed.
Which bench has heard it for several
My
days?
lord,
Which bench heard it for several days?
my lord, Justice Bosak and Justice Rishid.
Let us see. You were appearing.
My lord,
You were appearing.
and a very short point is the petitioner was promoted as accounts officer in 1994.
On which dates it was heard by the earlier bench? Which are the several dates on which it was heard by the earlier bench?
On the next day, I will give it.
Sir, there are 2 dates it was listed before that bench. On one day it has been dismissed in default.
No, my lord. Each day I appeared in that court, my lord. Yeah? After restoration, my lord, it was hard. Mr. Joydeep Kaur appeared for the respondents. It was hard for several days, my lord. Just after the, my lord, the change of determination, my lord, it has not finalized, my lord. It was just to be finalized, my lord. Well, a short point. He was promoted as accounts officer. Just after 1 month of his retirement, he was reverted. He was promoted on condition, my lord, that he will not get benefit of career advancement scheme. And he was denied the career advancement scheme. But when he was reverted, my lord, the entire benefit which he accepted as accounts officer, that was taken away.
That is not the point. What you said is it was heard in detail for several dates before an earlier bench.
Yes, I appeared, I
So
submitted.
that we are trying to see. We don't find that to be reflected from the order sheet. That is not reflected from the order sheet. It was heard on one day. Thereafter, it was adjourned. And it was adjourned for instruction. And then on the next day, it has been dismissed in default. Thereafter, never listed before that bench.
It was restored, it was hard, my lord, I tell your lordship.
We don't know.
Mr. Joydeep Kaur appeared.
We don't know whether to go by this or whether to go by what you are submitting. After restoration, it was not listed before that bench. After restoration, it was listed before the division bench of His Lordship Justice Chakrabarti. Thereafter, 3 dates before the Honorable the Chief Justice. So we asked you on which dates, several dates it was heard by Justice Debangshu Basak's bench.
Well, excuse me, my lord, I will check it up, then I will submit.
You cannot, because the entire record is before us. What you will check up? We are looking at it. There's nothing beyond this that can be checked up.
My lord, paper book has already been filed.
That is a different thing. When you say on several dates it was heard by a particular bench, that we are trying to verify, which is apparently not correct. Anyway, list after 1 week.
Recorded, my lord.
List after 1 week.
Mr. Joydeep Kaur appeared.
That is an incorrect submission from the
No, my
records.
lord, excuse me, my lord, I am submitting.
We excuse you, but it is incorrect.
I will ask Mr. Joydeep
It
Kaur.
is incorrect as per the records. Yes, call the next case.
Item number 16
and 17. 16 and 17 are identical matters. I am for the respondent. I'm for the respondent writ petition.
16 and 17.
Both are identical matters.
Where is the
But I am actually I have suffered a termination letter, termination, my lord. Thereafter, single bench, my lord, set aside the order of termination. And, my lord, thereafter, before the division bench, the contempt was stayed. Not to proceed with the contempt. And we are suffering, my lord, termination. Kindly
Yes.